Good afternoon, everybody. My apologies there for the slight delay. My name is Fiona Hanlon, and I'm the Events and Communications Executive at Compliance Institute. Thank you very much for joining us today on the 7th anniversary of the GDPR. We've been going through various topics such as key DPC decisions, AI and data protection, development of data subject access requests, and insights for compliance professionals. As always, it'll approximately take 1 hour. We will always have Q&A at the end, so please ensure to put your questions in and they'll be addressed at the end of the session. And the CPD code 2025-1396 and a copy of these slides will be sent to everybody once the session has concluded. So I'll hand you over to our presenters today from Maples Group, Claire Morrissey, Head of Data Commercial and Technology Team, and Sarah Lydon, Data Commercial and Technology Team. Thank you both.
Thank you, Fiona. Good afternoon, everybody. Welcome to our annual GDPR update. As Fiona mentioned, today we're going to cover 4 items. The first being DPC decisions. Secondly, we're going to discuss some key case law cases over the last 12 months. Then we're going to look at what's been happening in the space of AI and data protection. And finally, we'll turn to data transfers. Before we look at those issues, I'd like to mention the European Commission's draft proposal to simplify some of the obligations under the GDPR for small and medium-sized enterprises. So the Commission published this draft proposal in March 2025, and it relates in particular to the record-keeping obligations of organisations with less than 500 employees. I'm mentioning this because it's a case of watch this space, and on the 8th anniversary we may be covering that simplification in more detail, and I suspect that will be a relief to many compliance officers attending today's webinar. So starting with DPC decisions, the DPC has been quite active over the last 12 months, and in the first case, since May last year, we've got 7 decisions pursuant to which the DPC has imposed fines of over $1 billion on the large social media companies, and we've set out those decisions with the dates and the basic subject matter plus sanctions there for reference. We're not going to go through all of those, but you'll see we've highlighted 3 of the decisions in red. So almost half of those DPC decisions related to personal data breaches, and in our experience on a day-to-day basis, GDPR and data protection compliance most typically comes up either in the context of a personal data breach or a compliance with a data subject access rights. So we thought it pertinent to focus on 2 of those personal data breach decisions. We think there are key learnings, particularly in relation to what are the basic technical and organizational measures that are expected to be in place, and secondly, in relation to internal data breaches, which the Meta decision may have a surprising outcome for a lot of people at the webinar today. And then secondly, my colleague Sarah is going to talk about the LinkedIn decision. You might say behavioral analysis and targeted advertising. Why are we concerned about that? Well, the decision has got some really interesting insights in relation to legal basis and transparency, which are relevant to every controller. So turning first to the first personal data breach decision, that's Maynooth University, and that decision was issued in November 2024. This incident arose as a result of either a phishing or a malware, or a phishing attack or malware. Essentially, an employee's email box was accessed, and as part of this, up to 6 Maynooth University employee accounts were accessed. For one of those accounts, mailbox rules were set up to conceal emails. So the relevant email holder didn't know these emails were coming in, and the emails were being diverted to a third party. Because of this, there ended up being a diversion of a €10,000 pension payment from an MU employee. The data that was involved was identity data, PPSN numbers, contact details, economic financial data, and location data. As part of the investigation, they discovered that approximately 653 data subjects were potentially affected. I've set out the timeline in detail because one of the issues the DPC was looking at was whether or not Maynooth notified the DPC on time. As you all know, controllers have an obligation to notify data breaches without undue delay, and in any event within 72 hours of becoming aware. So the timeline here is really important, and it's quite instructive. So Maynooth University IT was made aware of the incident on the 10th of October when the employee who suffered the financial loss made them aware of it. Maynooth engaged an external cybersecurity firm, and they delivered their report on or about the 8th of November. Maynooth's DPO wasn't told until the 12th of November, and initial contact wasn't made with the DPC until the 15th of November. And a formal notification was then put in on the 19th of November. In terms of the failure to notify the DPC within 72 hours, the DPC found Maynooth had failed in this standard. Maynooth was arguing that it needed the external cybersecurity firm report in order to understand if there had been a personal data breach. And the DPC said no. They looked at the facts. They said that Maynooth University was told, the IT department was told on the 10th of October. By the 23rd, the university itself had realised that these email inboxes had been accessed by an unknown third party, and they had asked for passwords to be changed. So the DPC held that Maynooth was aware of a personal data breach by the 23rd of October, and they held that there was a 22-day delay in notifying the DPC. In addition, the DPC held that there was a failure to ensure appropriate security and a failure to implement adequate technical and organisational measures. What were the security gaps and the organisational failures? MFA was not in place for most users. There was weak anti-spam software, there was no software expiry, and there were no controls on email forwarding. There was outdated software in place, there was malware present, and there were patching issues. In terms of organisational failures, training wasn't universal. Key policies were missing or only created post-breach. There was no incident response or phishing policy at the time, and no clear data storage or password policy. In terms of the risk assessment, because as you know, not all incidents involving personal data are reportable to the DPC. The personal data breach is only reportable if there is likely to be a risk, or you cannot report if there's unlikely to be a risk to the individuals concerned. The DPC's and the EDBB's position is that you should almost report by default. Here, the DPC held that there were significant risks to the individuals. Those risks were financial fraud and loss of control over their data. Maynooth was issued a reprimand. Reprimands are intended to act as deterrents both to the controller involved and to other controllers. And they were fined 40,000. As you may know, public bodies can only be fined up to 1 million. So this 40,000 fine was 4% of the maximum fine that could be imposed on Maynooth. 15,000 was imposed for failure to notify on time, and 25,000 was imposed for breach of Article 5.1, the security principle. And you'll see in the DPC decisions that the core principles set out in Article 5 are really the primary focus of the DPC when they're looking at infringements, i.e. they're treated as being more serious than, say, the failure to report on time. So what were the corrective actions ordered? Implementation of MFA for all users, review and update of anti-spam and security policies, regular software updates and robust password management, e.g. forcing people to change their passwords frequently, but not too frequently, mandatory data protection and cybersecurity training, and development of comprehensive incident response policies. So the key takeaways from this decision are: you need to have a regular documented risk assessment. The GDPR and the challenges to personal data, they are evolving, they're changing, and you need to keep your practices and procedures under continuous review. For example, software that you put in place 12 months ago might not still be appropriate to the risks that exist today. Technical controls, MFA, up-to-date anti-malware and robust password policies, they are minimum expectations from the DPC. So if you take nothing else from this session, that they would be one of the things look at your technical controls. Are they in place? Do you audit them? Secondly, organizational controls. These policies need to be comprehensive and regularly reviewed, and staff training is critical. Breach notification. There should be immediate internal escalation. You'll see that the DPO here in the Maynooth case wasn't involved until after the cybersecurity report had been received from the external third party. The DPO should have been put on notice of the suspected breach from the get-go. As you all know, the DPC, the GDPR permits phase notification. So if you don't have all the information to hand in the initial phases, you can still notify and update that information. Finally, you should have an incident response plan. You should have it tested to make sure that it works, that the people, the contact numbers you have in that incident response plan are actually up to date. So Maynooth, we focused on this case because we think it gives practical insights into the issues that the DPC will look at in the context of your technical and organisational measures when it comes to personal data breaches. Then turning to our second personal data breach case, this is Meta Platforms Ireland, and the decision was issued in September 2024. The issue here was the inadvertent storing of user passwords in plain text. It affected millions of EU EEA users, and the passwords were accessible to certain Meta employees, but they were not accessible externally. The data that was involved were passwords. Not in every case, but in some cases that those passwords could be linked to other identifying information such as user IDs, email addresses, usernames and cookies. Again, millions of EU EEA users affected. The timeline here, again, relevant because one of the issues was failure to notify the DPC within 72 hours. The issue of plain text password logging was first discovered on the 7th of January 2019 as part of a regular review by a security analyst. That incident that was discovered on the 7th of January related to passwords that were stored in an obscure location, and there wasn't a huge volume, although we don't have exact numbers from the decision. They're redacted. A second incident was discovered on the 31st of January 2019, and this was a much larger incident and resulted from code changes, whereas the first incident was a software error. Meta notified the DPC on the 21st of March 2019, and the context for the notification was that Meta became aware that a journalist was about to publish a story on it, so notified the DPC in advance of that. The DPC found infringements again of Article 51F, failure to ensure appropriate security, failure to implement adequate technical and organisational measures, failure to notify the DPC within 72 hours, and also failure to document the breach. So turning now to the first question for this decision was there a personal data breach? The data was only accessible by employees. There was no third party that could access it. The DPC held this still amounted to a personal data breach because employees were not authorised to access unencrypted passwords. Internal unauthorised access is a breach of security, which can lead to unauthorised access or disclosures. Meta argued that there was in fact no unauthorised access here, i.e. employees didn't access the plain text passwords, and there was no evidence of abuse. The DPC didn't accept those arguments. Meta also argued that all of their employees were subject to contractual confidentiality. DPC also did not accept that would have put employees in the position of equivalent to trusted third parties that the EDPB guidance refers to. And then finally, in the context of personal data breach, you need to have access to personal data, and the DPC held here that the passwords were personal data as Meta could identify the individuals affected. So turning then to Article 33 and the notification, did they notify in time? The DPC held that they had breached this obligation. It found that risk to data subjects was not unlikely given the nature and scale of the breach. So firstly, Meta argued it wasn't a personal data breach because it was only internal and then there was no unauthorized access. And then they also argued that there was no risk here. The DPC didn't agree. They said given the nature and scale of the breach, there was a risk to data subjects. Documentation. As you know, under Article 33.5, all data controllers are required to document their risk assessment and the details relating to personal data breaches. Meta didn't do this contemporaneously to the satisfaction of the DPC and asserted legal privilege over its internal assessments as to whether or not it was a personal data breach. The DPC didn't accept these arguments. If you're looking to develop a template for the record of a personal data breach that you need to maintain, the DPC's decision has got a good table in the middle of it where it sets out the things that the DPC expects you to retain. What were the security failings here? So back to the core principle of security and integrity and the Article 32 obligation in relation to technical organisational measures. Meta argued that the DPC was effectively requiring Meta to have perfect security in place. The DPC said, no, we're not looking for perfect security, we're looking for effective security. Meta itself acknowledged that if it had implemented a sanitization framework on Facebook Lite, that the issues wouldn't have arisen, or certainly the 31st of January issues wouldn't have arisen. This was a state-of-the-art measure and it would have prevented the logging of plain text passwords. Meta also argued that it had put a number of measures in place, had done a manual review, implemented detection tools. The DPC held reliance on reactive measures was insufficient. And the DPC found there to be a serious and systemic failure to ensure appropriate security. So what are the key takeaways from this decision? Timely notification, notify the DPC within 72 hours unless risk is unlikely. Contemporaneously document the breaches and risk assessment regardless of internal legal advice. Ensure you've got state-of-the-art security, be proactive, look at preventative technical measures, especially for high-risk data like passwords. And when it comes to accountability, large-scale negligent failures to protect personal data will attract significant regulatory sanctions. And I will now hand over to Sarah, who's going to cover the LinkedIn decision.
Thank you, Sarah. So as you mentioned, I'll briefly discuss the LinkedIn decision. In October 2024, the DPC announced its final decision following an inquiry into LinkedIn's processing of personal data for the purposes of behavioural analysis and targeted advertising of its users. It was alleged that the processing was carried out, number one, without a valid legal basis, and number two, in an unfair and non-transparent manner. So the DPC made the following findings in respect of legal bases relied upon by LinkedIn. Firstly, on consent, the DPC held that LinkedIn could not validly rely upon this legal basis, as the consent obtained was not freely given, was not sufficiently informed, was not specific, and was not unambiguous. The DPC noted some key points with respect to consent, such as there was a perception of detriment created by LinkedIn's consent tool that influenced the data subjects to consent to the processing. For example, there was an implication that their ability to see relevant jobs would be impacted if they didn't consent. The DPC also noted that the information accompanying the consent tool did not sufficiently enable data subjects to determine the consequences of the consent. And finally, the DPC also disapproved of the consent options presented to data subjects and found that these nudged data subjects to accept. For example, the choices offered were accept and continue or manage settings, and the background colors for each of these options were not equal, with accept and continue being more prominent. In respect of legitimate interest, the DPC also held that LinkedIn could not rely on this legal basis, as LinkedIn had not struck the appropriate balance in its legitimate interest assessment. While the DPC found that there were some positive impacts relating to LinkedIn's platform, it did note a number of negative impacts, such as the large number of segments and inferences that may be drawn by users, the extensive use of inferred categories. We also noted that the use of interest categories derived from members' activities was intrusive. And the DPC also held that this processing was not the reasonable expectation of users. So while data subjects using social media platforms would expect some form of targeted advertising, this didn't extend to the use of certain inferred categories the use of bin data, or the use of analytics reports. And finally, in respect of necessary for performance of a contract, the DPC also found that this could not be considered to form part of the bargain between LinkedIn and its members. And just briefly on the DPC's findings in relation to transparency, the DPC found that LinkedIn's privacy notice only contained general reference to consent-based processing. The language used in the privacy notice was not readily accessible. The privacy notice did not set out sufficiently clearly processing activities in respect of which it relied on consent, and these were not distinguished sufficiently from legitimate interests. And as per the DPC's WhatsApp decision, the DPC also noted that the privacy notice did not establish a clear link between the categories of personal data, the purposes of processing, and legal basis. So the DPC imposed a number of corrective measures, which included a reprimand in respect of the infringements, an order to bring the processing into compliance, and an administrative fine of 310 million, which can be broken down as follows: 105 million for not validly relying upon consent, 110 million for not validly relying upon legitimate interest and performance of contract, and 95 million in respect of the breach of transparency obligations. So the key three takeaways from this case is that methods for obtaining consent must be fair and should not influence data subjects. It's also very important to carry out legitimate interest assessment and take time to conduct proper balancing tests during this assessment. And this decision reiterates some elements of the DPC's WhatsApp decision, namely that privacy notices should clearly link between personal data, the purposes, and the legal basis. So we will now briefly discuss some recent EU and Irish case law. And I will start first with some damages case law. So the first case is GP versus Juris GmbH from April last year. In this case, the plaintiff's personal data was used for direct marketing, despite having revoked his consent and having objected to the processing. The plaintiff sought compensation for material and non-material damages. And the Court of Justice was asked to consider a number of questions. So firstly, the court considered whether infringement of the GDPR itself constitutes non-material damage. And the court held that an infringement of the GDPR alone does not automatically constitute non-material damage. A data subject will have to demonstrate actual harm suffered. The second question was whether a controller can avoid liability if its employee fails to follow instructions. On this point, the court stated that the controller cannot avoid liability simply because the infringement is due to an employee failing to follow instructions. The controller will remain liable unless it can prove that the damage was not attributable to its actions. The third question was whether the criteria used for determining administrative fines can also be used to assess compensation for non-material damage. The Court of Justice highlighted here that administrative fines are supposed to be punitive in nature, whereas damages are supposed to be compensatory in nature. So this means that the rules for administrative fines will not apply when assessing the rules for compensation. And finally, the court also considered how compensation should be assessed where there have been multiple infringements of the GDPR. And according to the Court of Justice, the fact that multiple infringements have been committed by a controller in relation to the same data subject will not be taken into account when assessing compensation. It is only the damage that has actually been suffered that will be taken into account. So again, the key takeaway from this is that a data subject will need to demonstrate actual harm. The GDPR provisions on damages are intended to be compensatory, which means that the number of infringements will not be taken into account. And for a controller to avoid liability, they must prove that its actions were not responsible for the damage. And so the second case I'm going to discuss is JU and XO versus Scalable Capital GmbH. So in this case, the plaintiffs opened accounts with the defendant and provided personal data such as their names, date of birth, addresses, emails, and digital copies of their identity cards. This personal data were seized by third parties whose identities were unknown, but their personal data were not knowingly used fraudulently at the time the claim was made. And the plaintiff sought non-material damages. So a number of questions were referred to the Court of Justice, which made the following determinations in respect of non-material damages for theft of personal data. So the court stated that the right to non-material damages is exclusively compensatory in nature, similar to the case I just discussed. The right to material damages, right to non-material damages does not require the severity and the possible intentional nature of the infringement to be taken into account. Furthermore, where damage is not serious, a national court can award minimal compensation once this compensates in full for the damage suffered. In order for identity theft to give rise to compensation, the identity of the person affected must have actually been misused. And finally, as per the Court of Justice Austrian Post decision, for compensation to arise, a data subject must establish proof of infringement, actual damage suffered, and a causal link between the two. So I was just going to mention briefly a third case relating to damages, which is an Irish Circuit Court case, which demonstrates how the Irish Circuit Court is applying this Court of Justice case law. So in this case, a video was taken covertly of the plaintiff, who was an employee of the defendant, while he was on sick leave, which showed him helping to cut an overhanging branch. The video was taken by his senior manager and an operations manager. And the managers alleged that the plaintiff engaged in threatening and abusive behaviour when he saw this video being taken, and that this was a factor in the plaintiff's suspension and dismissal from the company. The plaintiff argued that the recording of him outside of the workplace without his knowledge or consent was a breach of the GDPR and the Irish Data Protection Act, and that he suffered significant stress and anxiety as a result of the loss of control over his personal data, and sought non-material damages. So the Circuit Court followed the approach taken in the earlier Circuit Court decision, which we mentioned last year, of Kaminsky versus Ballymacquarie Foods, which followed the Austrian Post decision, which I mentioned briefly earlier. And as I mentioned, the following three conditions must be met in order for compensation to arise, which is the infringement of the GDPR, material or non-material damage suffered, and a causal link between the two of these. And the Circuit Court found that there was a causal link between the actions of the managers and the plaintiff's ultimate dismissal. The Circuit Court ordered compensation of €5,500 for the damage suffered by the plaintiff and ordered costs in favour of the plaintiff. I will now hand you over to Claire, who will discuss a recent Irish case.
Thanks, Sarah. So data subject access requests. I mentioned at the outset that this is the second most frequent topic that we deal with in our day-to-day practice, and that's reflected in the DPC's annual reports since even before the GDPR was implemented. It's the most complained about right, and maybe it's also probably the most exercised right. So we thought you'd be interested in this High Court decision. This decision arose in connection with the HSE ransomware attack in May 2021. The applicant here was a fire protection officer with the HSE. He used his work phone for personal purposes. This was contrary to the HSE's policies. The HSE's acceptable use policy provided that work devices were for business use only, that personal use was at the HSE's discretion and required prior line manager approval. Confidential information could only be stored on those work devices with, again, prior permission. It also said that the HSE was not responsible for theft or fraud arising in connection with personal use of the device. There was a prohibition in the policies on access to Gmail, Yahoo, Fitbit, and other similar applications. And as part of the decision, the court noted that there was no evidence that the HSE mobile phones were impacted by the breach. So the McShane complained to the DPC, and the DPC rejected McShane's complaint on the basis that the HSE was not the controller of the personal data processed by McShane in relation to his or for his personal purposes. So we think that this will be quite helpful for all employers that are dealing with subject access requests. It would automatically exclude potentially a large portion of personal data. And the reason that the DPC found that the HSE was not a data controller for personal non-work data storage without its authorization was because the HSE did not decide the purpose and means of the processing. The individual themselves decided both the purpose and means. This was a judicial review. So essentially the High Court was being asked whether the DPC's decision was lawful. The High Court held that the DPC decision was lawful and that the DPC could hold that the HSE wasn't a controller. So hopefully that will prove of practical application to you. And one of the key takeaways here from this decision is to ensure that you've got really clearly documented acceptable usage policies and that your employees are aware of those policies. Turning now to our third topic, and that is data protection and AI developments. Since our seminar last year, a lot has happened. Firstly, the AI Act was published in July last year. It entered into force on the 1st of August 2024, and some of its provisions are now, so as you know, the AI Act entered into force and then there are staged compliance deadlines, and we already have passed the first of those, which was the 2nd of February in relation to prohibited AI and AI literacy. The next big deadline for everyone to be aware of is the 2nd of August 2026, and that relates to high-risk AI applications. And the reason I mention that is because the use of AI in connection with work-related decisions is considered to be high risk. So if you are using an AI to make decisions around which CVs to select for review or which candidates to select for interview, you need to be aware of the provisions in relation to prohibited high-risk AI. Not every use will fall within it, but you should be looking at those. So moving away from the AI Act itself, we thought we'd start with the timeline of developments in this space. The DPC has been at the heart of the developments in relation to AI over the last 12 months. In June last year, Meta suspended its plans to train its LLM using public content shared by adults on Facebook and Instagram across the EU EEA. This was after engagement with the DPC. In July last year, the DPC issued a statement on AI, LLMs and data protection, and we'll come back to some of the detail in that statement. In August 2024, X suspended its processing of EU users' personal data to train GORC after the DPC made an urgent High Court application. So it had become public knowledge that X is going to train GORC using EU users' personal data, and the DPC used this provision within the Data Protection Act to make this urgent High Court application. As part of that, or as a consequence of that application, X agreed to pause the processing of personal data. And sorry, I thought I had that date on that slide, but they agreed to suspend the processing on the 8th of August as a result of that High Court application. Then following that, in September, the DPC requested an EDPB opinion on personal data processing for AI model development and training. On the 12th of September, the DPC announced an inquiry into Google's PALM2, and the question at issue there is whether or not Google was obliged to carry out a data privacy impact assessment prior to using EU users' data to train the model. The EDPB responded to the DPC's request for an opinion on the 18th of December, and we'll touch on the detail in that shortly. In February of this year, Ireland, Australia, Korea, France and the UK data protection authorities issued a joint declaration on AI. And on the 11th of April this year, the DPC announced an inquiry into GORC LLM and whether its use of EEA users' personal data for training its model is lawful. So turning now to the DPC's AI guidance, which was issued in advance of the EDPB opinion. This guidance applies to all users of AI and LLMs. As part of this guidance, the DPC started by giving examples of the type of AI that's now in commonplace use. Those include chatbots based on Gen AI, which rely on underlying models that have been trained on large databases, often on the basis of publicly available data, which may include personal data. They also mentioned the ability of some AI to summarize documents, extract keywords, to assist with code development, and to assist with various forms of analysis or perform high volume repeat tasks. The DPC then went in to talk about what are some of the main data protection risks that arise with LLMs. And they are the potential for unauthorized or excessive use of personal data in training or in operation, the potential for inaccurate, incomplete or biased data leading to unfair or discriminatory outcomes, the potential for unintended sharing or retention of personal data, including through model memorization. So the issue here is that there are inherent risks with AI in relation to how they use personal data. And the example here might be that your LLM or your chatbot regurgitates the training data that has been input, and that could be personal data identifying various individuals. There are security vulnerabilities. The filtering that LLMs use can sometimes fail, leading to risks of data leakage or filter circumvention. LLMs are susceptible to use for automated decision making, and as you know, automated decision making, which can result in legal consequences or similar effects, are subject to special regulation under Article 22 of the GDPR, and human oversight is key where there are these automated decision-making processes. And then finally, absent appropriate retention policies, there's potential for non-compliance with storage, limitation and data minimization. So you see with all of these risks that they all have the potential to breach the core principles of the GDPR. For example, if there's unauthorized excessive use of personal data in training or operation, this may lead to breach of the first principle in Article 5 in relation to lawfulness and transparency. And obviously, the non-compliance with storage limitations and data minimization would also trigger the core principles. The DPC, however, had some advice on what to do if you are using LLMs or relying on them. The first is assess whether you're a controller or a processor. Conduct a formal risk assessment before you deploy the AI system that processes personal data. Understand what personal data is used and how. Where data is stored, processed, and by whom. Is it processed by a third party? How does the AI provider that you're using support GDPR compliance and data subject access rights? Ensure that you have processes in place to respond to those data subject requests, such as access or erasure. And review and manage risks from staff or data user published online that could be scraped for AI training. Implement robust data governance and security controls for your AI systems. Ensure that there's transparency with data subjects about what AI is used and the data processing. Regularly review and update retention schedules for personal data in AI systems, and monitor for and mitigate risks of bias, inaccuracy, and unauthorized data processing. And ensure that your contracts with third-party providers address GDPR compliance and data protection. So turning now to the EDPB guidance on AI models. The EDPB guidance looked at three questions. When and how can an AI model be considered anonymous? If it's anonymous, it falls outside of the scope of the GDPR. How can controllers demonstrate the appropriateness of legal interests as a legal basis in the development and deployment phases of AI models? And what are the consequences of unlawful processing of personal data in the development phase on the subsequent processing or operation of the AI model? So firstly, on the anonymity of AI models. AI models trained with personal data will not always be considered anonymous. Most of us will know that the standard for true anonymization under the GDPR is actually really high, and it's always evolving as technology evolves. So what are the criteria for considering data to be anonymous? You have to look at the likelihood of direct extraction of the personal data and the likelihood of obtaining personal data from the queries. The risk that personal data could be extracted or you can get personal data back from your queries needs to be insignificant. And you need to take into account all of the measures reasonably likely to be used by the controller or by a third party to try to identify the individuals. As to whether or not a model results in data being anonymized, supervisory authorities will need to conduct a case-by-case assessment. And as part of that case-by-case assessment, they look at the documentation that's put in place. They look at whether measures were put in place to prevent or limit personal data being collected at the training stages, what efforts were made to reduce identifiability, to prevent extraction, and is there state-of-the-art, are there state-of-the-art measures in place in relation to preventing or fighting off attacks. So then the EDPB looked at legitimate interest as a legal basis as its second question. And at the outset, it noted that there is no hierarchy between legal bases under the GDPR, i.e. consent, performance of a contract, legitimate interest. They're all equal, but they may not all be appropriate in the circumstances. So the EDPB talked about the traditional three-stage step for legitimate interest. 1, identify your legitimate interest. 2, ensure that the processing is necessary to achieve that legitimate interest. And 3, ensure that a balancing test is taken, is performed in relation to the interests of the data subjects. In order to rely on legitimate interests, that interest has to be lawful to start with, needs to be clearly and precisely articulated, and it needs to be a real and present interest, not a speculative one. And some of the examples of legitimate interest in the AI context given by the EDPB were developing conversational agents and improving threat detection and information systems. In relation to necessity, the EDPB repeated the usual test, which is it needs to be the least intrusive means to achieve your objective. In terms of the balancing test, one of the key features here will be ensuring that data subjects are aware of how you're processing their data. If they're not aware, that will make your balancing test much more challenging. And even if your balancing test finds that actually the data subject's legitimate interests outweigh the data controllers, the EDPB says that there may be mitigation measures that the controller can put in place to enable the LLM training and use to continue. So the third issue that the EDPB looked at was what is the impact of unlawful processing in the context of LLMs? And they looked at 3 models. The first is where the personal data is retained in the model and processed by the same controller. And probably worth really highlighting here that the EDPB opinion looked at the training phase, or development phase, I should say. So they looked at the development and then they looked at the deployment phase. So here, if you have personal data in a model that is trained by a controller and that processing is unlawful, what's the impact on the processing by that same controller when it deploys it? Scenario 2, personal data in a model was unlawful when carried out by another controller, and then it's processed in the deployment phase by a second controller. And then the last scenario is where the model data is anonymized before subsequent processing. On the first 2, the EDPB said it's a case-by-case assessment, which you can view as helpful or unhelpful. And in relation to the last point, the EDPB made the point that if the data is anonymized, the GDPR doesn't apply to it at all. And that comes back to what is the standard for anonymization. The EDPB does make the point that if that anonymized data is subsequently used to identify or somehow the anonymization is undone, you will be subject to the GDPR. The EDPB highlighted the importance of the accountability and being able to demonstrate compliance with the GDPR requirements in relation to the use of LLMs, and noted the corrective measures that supervisory authorities can issue. And then finally, as I mentioned, there's a case-by-case assessment on the impact on subsequent processing. We'll now turn to our final topic, and Sarah will take you through this.
Thank you, Claire. I'll now briefly take you through some key data transfer updates over the past year. So firstly, I will discuss the DPC's recent TikTok decision. As you may have seen, the DPC announced a 530 million fine against TikTok. on the 2nd of May 2025. This decision follows an inquiry launched by the DPC to examine the lawfulness of TikTok's transfers of personal data of its users in the EEA to China, and whether the provision of information to users met the GDPR's transparency requirements. So while the final decision is yet to be published, the DPC did provide some information on the reasoning for its decision. So firstly, in respect of data transfer mechanisms, the DPC held that transfers to China by TikTok infringed Article 46 of the GDPR, as TikTok failed to verify, guarantee, and demonstrate that its supplementary measures and the SECs were effective to ensure that the personal data of its EEA users were afforded a level of protection that was essentially equivalent to that guaranteed within the EEA. It's worth noting that during the inquiry, TikTok had shared its own assessment of Chinese law, which set out how aspects of the Chinese legal framework precluded a finding of essential equivalence to EU law. So, for example, their anti-terrorism law, the counter-espionage law, their cybersecurity law, and their national intelligence law materially diverge from EU standards. The DPC held that TikTok's failure to adequately assess the level of protection provided by Chinese law and practices directly impacted on TikTok's ability to select appropriate safeguards and supplementary measures. Secondly, in respect of transparency requirements, the DPC found that TikTok's privacy notice did not comply with the GDPR in 2 respects. So firstly, it did not name the third countries to which personal data was transferred. And secondly, it did not explain the nature of the processing operations and did not specify that the processing included remote access by personnel in China. As I mentioned, the DPC imposed a €530 million fine, and this can be broken down as €45 million fine for breach of transparency requirements and a €485 million fine for breach of transfer mechanisms. So the 2 key takeaways from this case are the importance of conducting your transfer impact assessments, which will allow you to determine what measures need to be put in place to protect the personal data. And secondly, that your privacy notices should be up to date to reflect the international data transfers undertaken by you and to provide sufficient information to data subjects on this. I also just want to briefly touch on the EU and US data privacy framework. So on the 9th of October 2024, the Commission completed its first review of the adequacy decision on the EU-US data privacy framework. And the Commission concluded that US authorities have put in place the necessary structures and procedures to ensure that the framework functions effectively. And the next review is expected to take place in 3 years' time. However, as you may be aware, there are a number of uncertainties in the US at the moment in respect of privacy. Just to give some examples, so firstly, President Trump requested the resignation of the Democratic members of the Privacy and Civil Liberties Oversight Board. And it's worth noting that the Commission's adequacy decision relied heavily on the oversight provided by this board. One other thing to note is that the Federal Trade Commission has also been given powers to oversee compliance of US companies that self-certify under the framework. But on March 18th this year, the White House removed 2 Democrat commissioners, which leaves only 2 Republican commissioners. And these changes could mean that the Commission is not sufficiently independent to enforce the framework. Also, as you may be familiar with the name Max Schrems, this is the individual who successfully challenged the EU-US Privacy Shield. He has recently commented that he may not need to bring legal action in respect of the framework, as the US government actions should prompt the Commission to proactively suspend the framework. So this is a bit of a watch this space in terms of whether Max Schrems will take any legal action in respect of this. And finally, just to briefly touch upon the UK adequacy decision. So this expires on the 27th of June this year, but we expect that this will be extended to the 27th of December because the UK government is currently in the process of finalising data protection legislation. We are just awaiting the European Commission to officially announce this extension. And that is it for our overview of the developments from the GDPR 7th anniversary. We'd like to thank you for your attendance today, and we hope the webinar has been informative. I'm happy to take questions if we have some time remaining.
And Sarah, I'm just seeing questions coming in on the chat. In relation to the last topic that you just mentioned, what is the impact of the DPC decision in relation to transfers to China outside of TikTok?
Yeah, so the DPC's decision in respect of transfers to China is specific to TikTok alone. So just to clarify that, there's no suspension of transfers to China, it simply applies to TikTok. But as I said, the importance of this decision is data transfer impact assessment. So everyone should make sure that they have reviewed their transfers, they've reviewed the laws and the practices in place in third countries, and determine what measures you need to put in place to effectively protect the personal data. And as I noted before as well, privacy notices should be kept up to date to reflect the transfers that you're undertaking, as this is a key part of transparency requirements.
Okay, and then I might take the next question, which is, was there a percentage of the 40,000 fine imposed on Maynooth University for not involving the DPO and not reporting within 72 hours? So the 40,000 fine was divided into 25,000 for breach of the Article 5.1f security principle and Article 32, and then 15,000 was imposed in respect of the failure to make the notification on time. The DPC didn't analyse as part of the decision the failure to involve the DPO, so there wasn't an individual element of the fine attributed to that. And then our last question on the chat is whether a DPIA is always mandatory for use of Microsoft Office and or for use of Microsoft Copilot. So a DPIA is only mandatory where there's likely to be a high risk to individuals. This will particularly arise where you're using new technology. Microsoft Office at its basic level has been around for a long time. So I suspect you would be able to justify not carrying out a DPIA for the use of Microsoft Office. However, when it comes to Copilot, even if a DPIA is not mandatory, and you can argue it both ways, it is certainly good practice and recommended by the regulators. So I think that's it for the questions that we have. Thank you everybody for your time and attention, and we'll bring the session to a close now.
That's great. Thank you so much. On behalf of Compliance Institute, I want to thank everybody for joining these updates today. I'm sure you found them very insightful in relation to enforcement, AI and international transfers. Thank you to our speakers, Claire Morrissey and Sarah Lydon from Maples Group. So as always, I'll be circulating the slides shortly. Until then, we look forward to seeing you at our next webinar. Thanks everyone and goodbye.